faculty. Now, now we have this CCTL, Corporate Law and Governance cluster seminar on Japan's corporate governance code from the perspective of sustainable growth of the company and the improvement of medium to long-term corporate value. Today we have the great pleasure of having Professor Hiroyuki Watanabe to be our distinguished speaker. Professor Watanabe is a professor of the Faculty of Law at Waseda University in Japan, Tokyo, and he has been in the current position since 2008. He has been engaged in research and educational activities in the fields of corporate law and the capital market law, as well as in areas of finance law and trust law. While he is interested in cutting-edge issues, he is also very interested in the legal ideas that underlie the events. Under the recent situation where the world is online, he has been actively publishing research results through SSRN, which stands for Social Science Research Network, which is a major online international research network. Now, we also have the great pleasure of having Professor Christoph van der Elst as our discussant. Professor van der Elst is a professor of business law and economics at Tilburg University in the Netherlands and the Ghent University in Belgium. He has advised many different government agencies at national and the EU level. He has held or holds several visiting professorships at the Vanderbilt University in the US, IDC University in Israel, CLEI Center, University of Toronto in Italy, among others. He is currently a European Corporate Governance Institute Research Associate. Now, without further ado, let me allow Professor Watanabe to give the talk. Professor Watanabe, over to you, please.
Thank you. I'm Hiroyuki Watanabe from Waseda University, Tokyo, Japan. My background on the screen is Kyoto's view. It's a great honor to join this seminar today at the CCTL Corporate Law and Governance Cluster at the Chinese University of Hong Kong. I really appreciate Professor Shi Chao and all the people concerned for their wonderful arrangement and great efforts. Today, Professor van der Elst kindly took on the discussant. I really appreciate also for his kindness and do look forward to hear his insight. So I'd like to share my PowerPoint slide on the screen. So I'd like to share this.
Take your time, Professor Watanabe. It always happens to me. Professor Watanabe, I think you have sent me a copy of your PPTs. If you don't mind, I can pull it out, and we can work together. If you can give me just 1 second, it's in my inbox, which is right here.
Oh, sorry. I can do. Okay. Okay.
Fantastic. Fantastic. It does come up perfectly.
Excuse me for taking the time. So I'd like to start today's today's topic is Japan's corporate governance code from the perspective of sustainable growth of the company and improvement of medium to long-term corporate value. The structure of my presentation is as follows. First, I'll explain background and objective of Japan's corporate governance code. And next, explain transition of the code and main revision items. And then, third, I'll scrutinize the code from the perspective of sustainable growth of the company and improvement of medium to long-term corporate value. It's the subtitle of the code itself. So, first, as for background and objective of Japan's corporate governance code, the code has been created and published by the Tokyo Stock Exchange, Tokyo Shoken Torikijo, and foundation of Japan's corporate governance code lies in Japan revitalization strategy by Abe administration, Prime Minister, and it has been formulated as part of Japan's economic growth strategy. It's the characteristics of Japan's corporate governance code. And Japan's corporate governance code take a principle-based approach and comply or explain approach modeled after UK corporate governance code, etc. Next, about transition of the code at the Tokyo Stock Exchange. As a predecessor of the corporate governance code, there was the principles of corporate governance of listed company published in 2004. I myself been involved the drafting of these principles. At that time, there has not been a good understanding in business community about the significance of corporate governance code. And typical reaction from business community is that why we introduce additional rule in addition to company law. But now things have changed. And in 2015, first Japan's corporate governance code was published. And the code was revised in 2018 and its current version. So today, I'd like to talk mainly about this current version and supplement forthcoming 2021 version, soon revised. As for the general principle of the corporate governance code, it's the same since the first 2015 version. 5 general principles. 1 is securing rights and equal treatment of shareholders. Second, appropriate cooperation with stakeholders other than shareholders. 3, ensuring appropriate information disclosure and transparency. 4, responsibility of the board. And 5, dialogue with shareholders. And please note that a note is added to each general principle, and there are many principles and supplementary principles in addition to the general principles. As I said, Japan's corporate governance code was revised in 2018. These are the main revision items. First, reduction of cross-shareholding, introduced by Supplementary Principle 141 and 142. As you probably know, cross-shareholding is one of the features of Japanese corporate culture. And now things have been changing by this corporate governance code and etc. And second main revision item is establishment of procedures for appointing and dismissing CEOs through introduction of supplementary principle 432 and 433. And third, understanding capital cost, leaving business portfolios, and allocating resources. These were added to Principle 5.2. These are main revision items in 2018 revision of the code. And now, some of them probably know now new revision, new corporate governance code is being introduced. And I'd like to explain main aspects of final proposal for revision of corporate governance code. It was issued 6 April this year, and deadline for comment was 7th May this month. And new corporate governance code will be published at the earliest next month in June, and within this summer, and will be implemented within this year. So one of the main aspects of revision is functioning of the board of directors. And requirement for independent outside directors. In final proposal for revision, for prime market, it's a market that upgraded the first section of current Tokyo Stock Exchange, Tosho Ichibu, which will be introduced soon. So this revision of corporate governance code is in line with the organization of Tokyo Stock Exchange market. And prime market is upgraded version of current section 1 of first section of Tokyo Stock Exchange. And for prime market, more than 1/3 of independent outside directors are needed, and majority are needed if there is controlling shareholder. Typically, there is a relationship parent and subsidiary listing. It is also one of the features of Japanese corporate culture. And for other markets, other than prime market, 2 or more independent outside directors are needed, should be selected, appointed. And if there is a controlling shareholder, more than, 1/3. And in addition to this, creation and disclosure of skill matrix for directors' experience and ability will be introduced. Skill matrix of each board of director members. Second aspect of forthcoming revision is addressing the issue of sustainability. First, it will introduce disclosure of sustainability initiatives and investment in human capital. And for prime market, additionally, disclosure of policies and impact on climate change within the framework of the TCFD should be introduced. TCFD is Task Force on Climate-Related Financial Disclosures, which was created by the Financial Stability Board. I suppose it's in line with the international trend in this area. And the third aspect of revision is ensuring diversity among corporate human resources. So the principle of diversification of managerial position will be introduced. It's specifically for women, holders, and mid-career hires. And voluntary target setting and disclosure are required. In addition, there is a need to disclose specific internal environment and human resource development policies and implementation status to ensure diversity. So far, I explained background, objective, transition of the code. And I'd like to move on next agenda. Scrutiny of the code from the perspective of sustainable growth of the company and improvement of medium to long-term corporate value. As I said, this is the subtitle of this code itself. And as I summarized in the forthcoming 2021 code revision, various directions will be introduced to promote sustainability and diversity and to improve the function of the board of directors. However, it seems that no specific direction has been presented for improving the earning power that is the driving force for Japanese companies to improve their corporate value over the medium to long term. So, my question is, does the current code provide or a forthcoming code provide enough principles and rules to improve corporate value over the medium to long term? And last point is main focus of this presentation. So from now on, I'd like to scrutinize the general principles and some related principle and supplementary principle. Here, please note that these general principles are same since the first version of corporate governance code. So, regarding general principle one, general principle one is for securing rights and equal treatment of shareholders. And below we find supplementary principle 112. When proposing to shareholders that certain powers of the general shareholder meeting be delegated to the board, companies should consider whether the board is adequately constituted to fulfill its corporate governance roles and responsibility. So it's supplementary principle about the delegation of shareholders' power to board of directors. My comment on this general principle one and supplementary principle is that we should understand that the statutory rights of shareholders at stakeholder meeting under the current Companies Act in Japan is much stronger than that of in the US. In Japan, stakeholder rights have been exercised on a wide range of matters at stakeholder meeting, including exercising a strong direct control over accountability of management oversight. In contrast, in the United States, function and authority to direct management oversight is being increasingly delegated to the board of directors, and stakeholder rights regarding stakeholders meeting are limited. For example, in the US, the decision on dividends is not a matter of resolution at the stakeholder meeting, and even if it is decided there, it has no legal effect. In addition, in US, regarding the amendment to the article of incorporation, if the board of directors submit a proposal for the stakeholder meeting, the stakeholder only have veto right, refuse right, and cannot present a stakeholder proposal. Next, move on to general principle 2 for appropriate cooperation with stakeholders other than shareholders. General principle 2 says that companies should fully recognize that the sustainable growth and creation of mid to long-term corporate value are brought about as a result of the result of the provision of resources and contributions made by a range of stakeholders. It's, in short, expression of a kind of stakeholderism. But there are some views in Japan that Japanese companies should not blindly take the stakeholderism management, which could weaken the management discipline. And they insist that if they take the stakeholderism, Japanese business would lose the power to earn money and gain international competitiveness, since our capital efficiency such as ROE, return on equity, and labor productivity are generally lower than in other major economies in recent years in Japan. So my comment on such view are that the low level of financial indicators such as ROE in recent years in Japan is, according to my research, mainly due to the low rate of return on sales, which means that Japanese companies have recently not been able to create many innovations that generate high profits. Therefore, even if ROE has been improved in the short term by buying back shares, the essential problem remains. So I think the key question is how to create innovations that generate high profits and help regain the original earning power into Japan. So related to the labor productivity is also closely related to industrial structural issues. For example, Japan is currently, unfortunately, the base for supply of raw materials and parts to United States and European companies, unlike before. Raising the prices of these products will increase labor productivity, but transformation of Japan's industrial structure is needed. So the problem, however, is not that simple, and enhancing management discipline by shareholders alone will not increase labor productivity, I suppose. Next, general principle 3 is for ensuring appropriate information disclosure and transparency. Here, in this general principle 3, we can find the word non-financial information. I'd like to comment on disclosure of non-financial information and ESG investment regarding this general principle 3. So to promote disclosure of non-financial information, there's a need to develop investment methods that focus on the relationship between ESG scoring, etc., and companies' performance or stock price, as you know. Recently, how to quantity these ESG indicators and link them to sophisticated ESG investment has been of great interest in financial markets. And as far as I know, some European institutional investors, it's Dutch, Robeco, for example, have been doing this for quite some time and very interesting. However, it has also been pointed out that it is difficult to measure results when indicators such as ESG scores are linked to the remuneration of directors and managers. There are also those who question the significance of the remuneration system that link the two. So regarding the improvement of ESG indicators through corporate activities, it seems that we should expect progress in ESG investment to be made by investors rather than linking the remuneration system to its successful implementation, I think. Next, general principle 4 is for responsibility of the board. This principle says, given its fiduciary responsibility and accountability to shareholders in order to promote sustainable corporate growth and increase of corporate value over the mid to long term and enhance earnings power and capital efficiency, the board should appropriately fulfill its role and responsibility. And the biggest main challenge is how to realize this. And here, I'd like to show the significance of growth pie perspective. The idea that both business and society can benefit might seem too good to be true. However, according to prominent finance law scholar and a friend of mine, Alex Edmonds, he wrote Growth Pie, the book Growth Pie, last year. However, research evidence suggests that companies that treat their stakeholders well deliver superior long-term returns to investors. It's a result of his huge empirical studies. And so creating value for stakeholders is not just a worthy idea, but also good business sense. I totally agree with this. And if company make social value the goal and remember the indispensable principle, of course, these points are very important. So more often than not, profit will follow. So we should return to the way of thinking that the company grows the pie. According to Professor Edmonds, it means social welfare. So company grows the pie by working to achieve its purpose under the oversight of under the oversight of shareholders, and as a result, enhancing the interest of its stakeholders. My comment on general principle whole and such argument is that according to its US discussion and ongoing revision of US corporate law, according to Professor Edward Locke, who is a reporter of the US ongoing restatement of corporate governance project, shareholder primacy does not mean the idea of maximizing shareholder value, but means that priority is given to the interests of shareholders when the interests of other stakeholders are with interests that of shareholders are fundamentally conflicting. Based on this way of thinking, a growth pie perspective in company management does not contradict with idea of shareholder supremacy, even under the US Delaware case law. Professor Locke himself admits this in his article. Next, last principle, principle 5 for dialogue with shareholders. This general principles say companies should engage in constructive dialogue with shareholders even outside the general shareholder meeting. And in addition, principle 5.2 for establishing and disclosing business strategies and business plans says when establishing and disclosing business strategies and business plans, companies should articulate their earnings plans and capital policies and present targets for profitability and capital efficiency after accurately identifying the company's cost of capital. So here, capital cost of capital is future. My comment on this principle 5 is that dialogue with shareholders is essential for sustainable growth of the company and improvement of corporate value in the medium to long term. However, in Japan, it has been said that actually, dialogue with shareholders has been mainly used by some shareholders who intend to increase the amount of distribution and share buybacks rather than from the short-term perspective. Some people say now in US activist activity has been decreasing, and now Japan is the paradise for activists. So the perspective of dialogue in line with long-term improvement of a company's value has not been sufficient, I suppose. And I'd like to comment also on principle 5.2, establish and disclose business strategies and business plans regarding capital efficiency and research and development investment, etc. When evaluating company, it's necessary to increase the weight of evaluations over the medium to long-term span and to develop new practical indicators that match long-term growth and profitability. It's my view, but may hard to realize. So, at the very least, we should consider company profits in comparison to total procurement cost, that is debt plus capital, and so forth, such as return on invested capital, ROIC, are not solely with capital costs. For example, the buying back of shares improve ROE figures, but ROIC figures are not improved by such an action. And I think even if ROE is used, will be used as one of the main indicators for the time being, it should be emphasized that the period of ROE measurement is not only in quarters or years, but also in decades. Not only short time, but also long term. So here, I'd like to summarize my comments on Japan's corporate governance code from the perspective of sustainable growth of the company and improvement of medium to long-term corporate value. First, although the statutory rights of shareholders at the shareholder meeting are much stronger than those of the US, under the Japanese Companies Act, it seems that the focus of the Corporate Governance Code is still on strengthening the rights of shareholders. But here, I should supplement. It is true that traditionally in Japanese companies, shareholders have not exercised their power so much. So, it's structural corporate governance problem in Japanese company. But please remember that Japanese Companies Act basis statutory right of shareholders at shareholder meeting are much stronger than those of the US. So I think it's one of the main reasons that Japan is recently called activist paradise. Second, as for the dialogue with shareholders, that is shareholders engagement, perspective of dialogue in line with long-term improvement of company value is not sufficient. Third, due to the influence of the code and corporate governance code and stewardship code, etc., Japan takeover defense measures and cross-shareholding and Japanese listed company have been waning, decreasing dramatically in recent years. It should be recognized that the number of companies that plan to delist is rapidly increasing because pressure from shareholders has grown significantly in recent times. Fourth, as for the low level of ROE and other such measures in Japan, even if the figures are improved in the short term by share buybacks and other moves, essential problems will not be solved. So, measures should be taken to create more innovations and regain earning power. So, as a conclusion, I'd like to say that in the forthcoming 2020 code revision, various directions will be presented to promote sustainability and diversity and to improve the function of the board of directors. However, from the point of improving the earning power, that is the driving force for the Japanese companies and improving the corporate value of the medium to long term, Japan Corporate Governance Code have not provided enough principles or rules, and the code is still, Japan Corporate Governance Code is still under the developing stage from this point. I suppose many of the participants today are very interested in the details of the forthcoming revision of Japan's Corporate Governance Code. As I told, forthcoming revision will be published, fixed version will be published soon, around next month, at least it's within this summer, and we supposed to be implemented within this year. About the new version, the revision of corporate governance code, I'll post my revised paper or post a new paper on SSRN, Social Science Research Network. It's all free download. And soon after, New Japan Corporate Governance Code was published. So below is my current version of paper. So, just a little too early. If possible, I'd like to stop my presentation here. Okay?
Definitely, Professor Watanabe. Well, thank you for your very informative and illuminating presentation and sharing with us your very sharp observations on the Corporate Governance Code, which is forthcoming. This is a very important development, and we have learned a lot from your presentation. Thanks a lot. Next, I think we should invite Professor Van der Ost to join us for a discussion, please.
Thank you very much, Professor Xi, for this invitation, this kind invitation, and the Chinese University of Hong Kong for setting up this seminar. I think it's of great importance that internationally speaking, we come together and that we also exchange some views from different areas around the world. So thanks for that. Secondly, also thank you, Professor Watanabe. It's a very interesting presentation about the in fact, the current state of the art of the Japanese corporate governance code, as well that you also highlighted already what we can expect in the near future. And obviously, together with you, I'm looking very much forward to the final publication of this new corporate governance code. Now, in many ways, I fully agree also with the views of Professor Watanabe, in particularly with respect to the position of the stakeholders, as he also referred to Professor Edmonds of the London School of Economics and his interesting book, that if you also, in fact, take into account the position of the stakeholders and you treat them well as a company, then it finally also ends up good for the company itself as well as for society. So I also appreciate them very much that sustainability as such in the revised code of Japan is much more stressed. Now, what is, I believe, similar towards the new code compared to the previous code is that it sticks to the 5 general principles that in fact contains 3 major issues that were also highlighted by Professor Watanabe, which is first of all the position of the shareholders that is key, and it needs to be stressed that they obviously need equal treatment and that it should be cared for that the shareholders also can make use in an optimal way of all their rights. Secondly, that there is also a dialogue with the different shareholders, and I'll come back to this issue because on the one hand side, this is a great opportunity also to engage shareholders and point them at their duties, also to take into account that they not only should have rights, but also a number of duties, in particularly also vis-a-vis stimulating the board of directors to take action in the interest of the company and as such in the interest of sustainability. Third element is then also that there should be cooperation with the stakeholders, which is also a key feature of the Japanese corporate governance code and certainly also needs to be stressed. There is one, I would not say an outsider, because this is much more heavily stressed now in the new revision that we can expect, element that is also put towards our attention, which is the responsibility of the board of directors. And that actually is now more emphasized than it was before. So the new code will be providing a number of elements that certainly in the European context we are already more familiar with, like the diversity that should be enhanced in the corporate boards of Japanese companies, with which we are already in the European context more familiar. Without saying whether this is good or bad, it is certainly an element of importance to be stressed in the Japanese corporate governance code. Now, having said this, there are a number of similarities, obviously, and a number of differences. As similarities with, let's say, the European corporate governance codes that I'm more familiar with than the Japanese is the disclosure requirements, the cooperation, the equal treatment, and that directors must fulfill its responsibilities. Having said this, I also noticed, and that is, of course, maybe also more of interest to be discussed, and later on we can have questions about it, a number of differences with different European corporate governance codes. And we can enumerate a large number of them, but I want to in fact stress two, and there is one, in particularly the position of the shareholders, that I want to stress a little bit further. Differences with European corporate governance code still is that, relatively speaking, the Japanese code is putting a lot of emphasis, but not to the same extent putting emphasis on a number of particular features of the composition of the board of directors and the role of the board of directors. Meaning that with respect to board composition, there is indeed now an enhancement to put more pressure on the diversity, to also take into account that it should not be only directed to the I would almost say profitability of the company, but in fact also keeping track with the composition, that it can be helpful to deliver better performance of these companies. A number of elements of board committees are to be found, but also in particularly due to the, let's say, significantly different structure of Japanese companies. With this, let's say, I would say almost a statutory auditors board next to the board of directors, which we are familiar with the two-tier board structure also in a European context, but it is still a little bit differently structured than it is the case in Japan. The assessment, in my view, of board committees by the Japanese corporate governance code is less stressing these elements than it is doing this in European context. Also, you now found some elements with respect to director selection and succession and on remuneration, and in particularly if there might be conflicts of interest. But to simply also, for in particularly also the audience, illustrate that even taken into account the new developments of the Japanese corporate governance codes towards more emphasis on the board's position and role and composition, I still believe that in a European context, many of the corporate governance codes go even one or several steps further. I simply have now highlighted one particular principle of a Dutch corporate governance code of 2016 with respect to the selection and the appointment of board committee members and the role of the nomination committee. And as you can see, there is quite substantial detail as to the role and the duties of this nomination committee that should be installed at the level of the supervisory board in Dutch companies, what they have to take into account. They have to establish criteria for procedures for board members. They have to assess also whether the size and the composition of the management board is appropriate. Even if their own board, the supervisory board, they should do the same thing. They periodically have to assess the functioning of each member of it. They have to draft a plan for succession of the management board in detail, and also for supervisory board members, and make proposals for appointments and reappointments. So in fact, it goes in pretty much details. Having said this, and maybe it's also an interesting feature for the later discussion, I'm not in particularly keen to have all these details provided in a corporate governance code. It's simply illustrating that there are a number of differences. Why I'm not particularly keen is I'm a strong believer of nudging, meaning that if you in fact emphasize a number of elements, that automatically there is also an interest of people to take a look at it and be influenced, even sometimes not explicitly being influenced, but implicitly being influenced by simply knowing that a number of these criteria are in place. And that can in fact result to a higher level of compliance, which might be ultimately an important goal to finally end up with better performance. But that can only work if obviously these rules that are presented as best practices indeed can make the difference, and when they are indeed expressed so in such a specific way, are taken up by the boards of directors in a company in an appropriate way. And here I have to admit that I'm not sure whether a more general nature would be better, so that you leave more options, like it is the case in a Japanese corporate governance code, or whether you need to have more strict and more detailed rules provided so that it can provide in an appropriate nudging perspective, if I can say so, in a European context. So I leave it a little bit open, but I simply wanted to stress that I do see significant differences between these two standard settings, Japanese one and European ones. The second thing I want to stress, and that I really also noticed when both reading the Corporate Governance Code as well as the paper of Professor Watanabe, was that in European corporate governance codes, we don't do the same way as stressing that the financial fiduciary responsibility of the board of directors is all the time vis-a-vis the shareholders. You see it already explicitly provided in the general principle 4 of the Japanese corporate governance code. And this in light of enhancing also the earnings power, which is in particularly then once more stressing the financial results of the company. Once more, I'm not saying that is a bad thing, and we all have to be honest that a company should make profit. Otherwise, it goes out of business, maybe in the short, not in the short term, but definitely in the longer term. But stressing this was striking me. And you find it also in other principles and even notes. And both the different boards of directors should bear in mind their fiduciary duty and responsibilities towards the shareholders, also in principle 4.5. Due attention should be paid to the fiduciary responsibilities of the shareholder towards the shareholders. So it is stressed again and again. This is not something that you can find in a similar way in European corporate governance codes. And I simply also, as a matter of illustration, refer to 6 different codes, because obviously Europe is not one country, and we still have in all the different European member states and outside Europe, in particularly in the United Kingdom, different codes that also regularly are under revision. But what I simply have taken is the latest edition of these corporate governance codes to find out whether somewhere there is also, either for the overall board of directors, if you have a one-tier board, like it is the case in the United Kingdom, or in particularly for the management board in those countries that emphasize the role and the position of the two-tier board structure, like it is the case in the Netherlands, or even more in Germany, you always find that they never stress the shareholders as such, but either the company or the enterprise, or put it differently, the operational activities of the company and not the shareholders. It is the case already in the first principle of the Dutch code that the continuity of the company should be the most key important element to be taken on board by the management board, according to the Dutch Corporate Governance Code of 2016. UK Code of 2021 is phrasing it a little bit in a similar way to promote the long-term sustainable success of the company, not of the board of directors, and not of the shareholders. Obviously, notwithstanding this, the role and the position of the shareholders in UK companies is still key. They also, and you can see it also in section 172 that I will later onwards refer to, that the company comes first. Definitely in typical other continental countries, like in France, it is emphasized the position value creation by the company. So they should take it into account, the position of the company. The German code, even there, you find that it is responsible, the management board, for managing the enterprise in its own best interests. Not in the interest of the shareholders, obviously they are part of it, but it is a broader perspective. Similar elements you can find both in the Belgian code as well as the recent Italian codes, both dating from 2020. So pretty recent, they have also been revised. Now, the second element that is in fact going hand in hand with the emphasizing the role and the position of the shareholders in the Japanese Corporate Governance Code is also the idea of what does it actually mean and what you should strive for, this so-called sustainable growth. So what I did, and I apologize that I have used a very, I would almost say, imprecise way of approaching it by taking the Japanese Corporate Governance Code and through Adobe simply searching, so when do I find sustainable growth in the code, and I found 10 hits. One in the general intro that I'm going to skip, but you find it already, these elements of sustainable growth into general principles. Number 2, sustainable growth, and that should be brought according to this principle as a result of the provision of resources and contributions made by a range of stakeholders. At least what you see here, which I also endorse obviously, is that now they put they stressed the role of the different stakeholders in providing resources. So not only shareholders providing capital, but definitely also the other stakeholders, like probably the employees, but also the suppliers or the creditors. But next, and there we go a little bit further, it is emphasized that the sustainable growth will come by engagement in a constructive dialogue with the shareholders as one of these elements. So that should be, that's the way that I read it at least, it is stressed that it comes from a constructive dialogue that we shall see in these Japanese companies then sustainable growth, which is not necessarily always something that I immediately will envisage, but it could be, of course, part of it. It should, I believe, be put a little bit in a broader perspective. Some further elements where in the principles you can find once more sustainable growth. In fact, in these new rules that will be enacted shortly also with respect to board diversity. And this diversity will also support sustainable growth. I hope, for instance, that it is simply also a language issue that I misunderstood because it is stressed that it supports if you have more diverse boards, including more women on the board of directors, that will support their sustainable growth. I obviously do believe that they wanted to say the sustainable growth of the company and not the sustainable growth of the participants in the board of directors that will be more dispersed. So maybe I'm misinterpreting it. What actually is their meaning here? Second thing is also for stressing the role of the independent directors. That also should have as an aim that it shall contribute to sustainable growth. Also here I have a little bit of an anxiety, I would say. It seems a little bit that first independent directors are selected and put into the board of directors. And then the next step is that these independent directors should then have as an aim also the contribution to sustainable growth. I hope it's a combination. And I do believe that this is also something that they want, because I also understood Professor Watanabe's elements that he put forward. In fact, that there shall be some kind of a skills matrix available, a little bit like we sometimes already find it in a number of US proxy statements, where the board of directors is then also put into a matrix with all the capacities that they have. Or the Dutch, in fact, provisions in the Corporate Governance Code, where it is even emphasized that the supervisory board must come up with an appropriate composition and the expertise that should be available. So that means that independence is, of course, not first put as a criterion in the matrix, but simply also you have the whole skills that you want in the board of directors. And hopefully the independent directors will, of course, bring in a number of these elements that can contribute to sustainable growth, so that it is more of a matrix approach and not instead of an approach. First, we elect independent directors, and then we try to find out how these directors will contribute to sustainable growth. So that is also a sequencing element that that struck me when I was reading the corporate governance code, the Japanese one. They continue, for instance, also with a number of other elements for bringing or going towards more sustainable growth. That is also respond to requests from the shareholders, which is a good thing, obviously, to also take into account the remuneration system that can be providing an incentive to generate sustainable growth. Also, and obviously, I agree with Professor Watanabe's view that this is not the only element. It should be, of course, be broadened and put into perspective within the overall corporate governance practices that have been and that are applied by the Japanese company. And then there are also some hits in the notes with referring to sustainable growth, like the cooperation. It is stressed in particularly with the different kinds of stakeholders and the engagement and in dialogue with the shareholders. It brings me to some summary about this element. And I apologize vis-a-vis Professor Watanabe that I limit myself in particular to only a limited number of his presentation that contains so much materials. But I limited it to sustainable growth and the position of shareholders, if I understand it correctly. And it will be continued in the 2021 Japanese Corporate Governance Code. In fact, the sustainability comes from the resources and the contributions of different providers, the stakeholders, good element. But also by engaging in a dialogue with the shareholders. And I'll be honest with you, I'm then a little bit stuck here. Because first of all, isn't it a mechanism in order to take up by a board of directors to then translate it in some kind of a strategy that finally ends up in hopefully better sustainable growth, and that it not as such brings new sustainable growth? So a little bit also, what exactly, and I couldn't find it in the corporate governance code right away, the key question, what do you understand, according to the Japanese perspective of this Japanese corporate governance code, what sustainable growth is? It seems to be that they particularly stress the creation of innovative solutions that can generate high profits. Fine, I think it's a good idea of going in this direction, but then also to regain earning powers seems to be once more emphasizing to a very large extent, or maybe I'm looking at it in a wrongful way, I hope it a little bit, the, let's say, maximization of profit and not necessarily bringing into context some other elements. Second thing is also, what is exactly this engagement in a dialogue? What does it mean? There is a hint, at least if there is major opposition during a general meeting of shareholders, you should be in touch as a board of directors with the company. And I'm a little anxious to know whether this is the only way of dialoguing with the shareholders. Why is this? It could be the case, and this is also already visible, for instance, in UK companies that already for a longer period of time are in an active dialogue with the shareholders, that you also need to develop a dialogue with the shareholders before you are doing something and not a little bit afterwards where you only have a voice of the shareholders that disagreed with something that has been put on the agenda of the general meeting of shareholders. So for instance, if you start developing a new remuneration policy for the board of directors, I think it could be a good idea with your major shareholders to enter into a dialogue and not wait if you present them, for instance, this remuneration policy during the general meeting of shareholders, presented for the first time during this meeting to find out that a number of shareholders might disagree to the extent that you then have, let's say, a significant number of shareholders voting against some of the agenda items because they are unhappy, for instance, with this remuneration policy. So I hope that there is some kind of an active stance also in this dialogue towards shareholders. And then the third element is there needs to be sufficient cooperation with the stakeholders. Absolutely agree here, but I also hope a little bit that in the final corporate governance codes, there will be a number of elements provided that could highlight what exactly this cooperation might mean. How do you cooperate with stakeholders? What does it entail? What are the elements here? Because of course that can go in different directions. One of them, and I do for instance not know, and I apologize once more, the Japanese structures vis-a-vis their employees. Europe, for instance, has employees councils within which you also have a debate, in particularly the number of the board of directors, with the representations of the employees. And that can be helpful also to create a social balance, but also a peaceful collaboration of capital with labor. I'm not sure, because there is, as far as I could read in the code, not directly any kind of a hint what it can contain, this cooperation with the stakeholders. And I do hope, and this is my latest referring to this nudging element, that by bringing in a number of elements in this corporate governance codes, that what could be at least elements that could enhance the dialogue, that could create this cooperative nature with the stakeholders, that it can nudge also companies towards a good direction of further stressing an appropriate way of corporate governance best practices in these Japanese companies. To end up, to give you a little bit of an idea, given the recent, that is what I read, given the recent growing interest in social and environmental problems worldwide, this positive stance towards ESG should be part of the cooperation. It could be a very interesting way forward how to structure this cooperation. And it can also be helpful without having the strict mandatory rules even that you can find in French law, in UK law, where it is now being hard law that might not be optimal, that the board of directors should act not only in the interest of the shareholders and have their fiduciary roles towards the shareholders, but even in the law itself, it is provided that they should act in accordance with its social interests, taking into account environmental and social issues. Law in France, by the way, you could find similar elements also in the United Kingdom's Companies Act, sections 172 of 2006. So actually, I hope that Japan is going in this direction by having it as a little bit as best practices in order to avoid what I do not necessarily support, this stressing towards hard law, towards taking into account more sustainable and environmental aspects in your activity. That it should be more general and open to companies to prove that they are doing it in such a way for which a corporate governance code can in fact be very helpful. These were my preliminary, I would almost say preliminary comments, Professor Shi. I hope that by this it can bring in maybe also some debate, eventually responsive for Professor Watanabe, and I am gladly giving the floor back to you to see what can be done next.
Thanks a lot, Professor Van der Elst, for really bringing us such a fascinating dialogue, really, between Europe and Japan in respect of their approaches to corporate governance code. I think you have highlighted all these similarities and differences, which really, in a way, surprise us, given that these two economies are otherwise similar in terms of, for example, their corporate finance system and as well as their shareholding concentration. That's just fascinating. We have actually got about 20 minutes for Q&As, and I have already received a long list of questions from the audience. So if you don't mind, I will start into the questions. The first question came from the Dean of CUHK Law, Professor Lutz Christian Wolf, who is here with us. I will just read out his question to our speaker and discussant. Thank you for the great presentation by Professor Watanabe and the excellent comments by Professor Van der Elst. The stakeholder approach was basically abandoned in the late 1990s due to corporate disasters like Enron. Do we see a revival of the stakeholder approach in Japan and or in Europe? Why don't we, Professor Watanabe, would you like to start?
Okay. I think it's not just a revival of previous approach or thought. It's not just a stakeholderism. And it's coincide with, it can coincide with stakeholders engagement, I suppose. And for example, talking of US business roundtable, it has dramatically changed from stakeholder oriented view to all stakeholder approach. But what is important here is great big institutional investor totally agree with this new approach. So in the long run, a kind of stakeholderism, not focused only in stakeholder interest, will win in the long run. And from the point of earning interest, I suppose. So I suppose it's not just a revival of all the stakeholders' needs. So to earn more, we should abandon to stakeholder-oriented approach, I suppose.
Thank you, Professor Watanabe. Professor Van Dels, would you like to say a few words?
Well, a very few words, because I do believe that your dean is absolutely more, in fact, knows more about the situation in a number of European member states than I do. But in fact, I'm not sure you can call it a revival in that way that I'm not. So yes, there is a revival, but was it really also fully away? It returned for sure, and it is back, and it is back at a higher level than it was before. Because what I do see is supported by the recent European steps by the European Commission, by the European Parliament, that is now stressing, based on a number of reports, to take up sustainability in several ways and in different ways. And it brings us too far to go in every detail. And at the same time, also at the national level, in a number of countries, you see that it has been stressed. The national law in France, for instance, the loi de vigilance is one of them, but also in the UK now, one of their departments, business departments, recently provided also an extensive report that they invite us to comment on, to in fact emphasize also the role of companies in the whole sustainability debate, and that they should come up with more than that they have done so far. So you see this development. I'm keen that they will incorporate it into legislation. I'm pretty anxious about it because we all know that the bottom line for companies is still that they should be run to the extent possible, of course, taking into sustainability, but they should take into account also their fiduciary duties towards shareholders and towards creating profits too. So it must be manageable. From that perspective, I really also hope that Japan is going in the right direction in that perspective to emphasize it in a code and not necessarily going towards hard legislation. So brings in a little bit perspective. But yes, Professor Wolf, it's back. But I don't think it would completely disappear.
Thank you, Professor Van der Elst. We have two questions coming from Mr. Wan. I think I can see on the screen. The first question goes to Professor Watanabe. which I should read out. Presuming, for the sake of argument, that de-emphasizing activism in Japan is the right way to go. Isn't it true, however, that unless Kuruchu cross-holdings are eliminated to avoid a dominant shareholding structure, Japan would still need activism as a monitor? Do you agree? This is a relatively long question, but I will read it out. And as a follow-up question, if you do agree, what is being done to eliminate comprehensively what is being done in Japan to eliminate comprehensively the cross-holding structures? You note it has been dramatically reduced, but they do continue to exist. Is that correct? Professor Watanabe.
Yes, thank you for the question. As for the cross-shareholding relationship in Japan, as I said, it has been dramatically decreasing, waning, but still exists. And it's related to Professor Van der Elst's presentation. I totally agreed with shareholders' engagement and oversight. It's fundamental premise of modern company law, I suppose. So, what I present as stakeholderism is to cooperate with such shareholders' engagement and oversight. And I think it's totally possible to realize both elements. It's okay?
Yes, that's very helpful. That's very helpful, Professor Watanabe. So from this gentleman, we have a question for Professor Van der Elst, which I will read out. You mentioned that shareholders should be engaged, presumably to impact on the board and obviously to engage in constructive dialogue. But practically speaking, why would small shareholders have an incentive to do so? Directors know that they likely will not vote, so their jobs are not really at risk, and they are prone, in fact, to engage in management agency conflicts. If you agree, does that not mean that only activists who have a sufficient stake or dominant owners would have an incentive to monitor the board?
Okay, thank you for this question. I'm not sure how, so I can bring a story, but then it goes a little bit further than what is provided in a Japanese code. I'll try to be brief. So first of all, a small shareholder is a small shareholder. If you have 100 shares in Shell, you will not make the difference, that's for sure. Question is then just how to get in touch and how many shareholders you have to reach out in order to have a certain way of thinking of these different types of shareholders. So that depends on the ownership structure. So I can't put a direct direct number for it. But for instance, I'm investigating one company in very detail, and I found out that 7 shareholders do make the difference. So, and it is a large Italian listed company. So I'm not going to emphasize, but because this is not Japan anymore. They can get in touch with these shareholders and maybe with a little bit more. Because what I found out is, for instance, and here there are 2 possibilities, found out that those 7 decided everything. Whilst, for instance, during the meeting, there were 5,000 shareholders participating, either electronically, either in person. More than 90% said no, objected to one particular item, whilst the 7 finally decided they should go. So that's the first thing. So obviously, for the very, very tiny ones, that is not directly possible. There is, however, a second element that should be put into perspective. UK has introduced it, India has now introduced it, and it seems to at least provide a better voice for many more shareholders. That is, if you have a controlling structure, meaning the company is under the control of a larger shareholder, which is in many, many countries, in fact, the common type. That in those cases, for the independent directors, you should not only strive for a majority in the general meeting, which already is there, because if the largest shareholder does not approve, he will never be standing up this independent director for election, because it will be dealt with before the general meeting takes place, that he or she will not be listed as a proposal for an independent director. But that during the meeting, also the majority of the minority should be reached. If you bring in that element, then you give voice to many more shareholders and express the concerns if this is not the case. And through these mechanisms, you could also influence in a significant way, at the first time, the composition of the board of directors, and in a second way, also the willingness of the engagement of shareholders. And not only the largest one, and not necessarily the activist one, but a larger number of them. Having said this, and I can even further develop that one, but I don't want to monopolize the discussion. Having said this, it already is an important step towards much more engagement of many more shareholders than we currently might see, and overcoming partially the agency conflict.
Thank you, Professor Van Oost. Well, I sense from both our speaker and our discussant a good sense of optimism, which is very good saying. Now, we have a couple more questions. We have this question from Chen Chen, and this question regards the delisting of companies in Japan. The question is, are those delisted companies, I suppose by way of delisting, are they actually improving their earnings? And also, do those delisted companies, do they actually concentrate in certain sectors or industries? I guess this is a question for Professor Watanabe.
Yes, I don't disagree with your point, but it is true that in Japan, some cases are for avoiding too strong market pressure. As a background of delisting through management buyout, I suppose. And I'd like to add some comment to previous question. So
yes,
yeah, okay. In response to activism intervention, if I understand it as shareholder engagement, I totally agree with this concept. But regarding the effect of activists on corporate management, the result of empirical research has been divided. So we should scrutinize these empirical research, I suppose. Thank you.
Thank you, Professor Watanabe. We're running out of time, but there are really a couple of more questions. So I had to use the liberty to choosing just one last one. And this is really about diversity, board diversity, which I think both our speaker and the discussant have really gone into. So the question is, the board diversity requirement apparently seem to focus on gender equality. So the question is really, are there any other aspects, for example, nationality, race, age, in either, let's say, Japanese corporate governance code or in any of the European corporate governance codes? Professor Watanabe.
Yes, to my understanding, in forthcoming revision of Japanese corporate governance, other element, some elements other than gender will be introduced.
Okay, thank you, Professor Watanabe. Professor Van Elst?
Well, I also saw in the code that it is not only the Japanese code about women, but that there are also, well, about gender diversity, but that there are also some other elements put to the fore, which is a good way. And this is also in most of the corporate governance codes in the European context. We talk about diversity in several elements with respect to expertise. That should be, of course, be key. Nationality eventually, but please don't turn these elements into some kind of mandatory standards, because that will end up in companies running into difficulties to take into account the specific markets and the specific industries and operational activities that they envisage. So there should be significant liberty in that perspective. But as far as code is certain, most of the European codes, and now also the Japanese code, do put to the fore not only gender diversity, but also other elements of diversity, which is a good development.
Thank you, Professor Van Elst. We're really running out of time, but since we do have a dean here today, Professor Wolf here today with us, perhaps why don't we just ask our dean to say a few words and give this session, this seminar, a good close. Sorry for the surprise looks. I think you are still on mute. We can't. All right. That's all right. So I guess the dean has given me the instruction that it's 6:30 local time, and it's time really. I think it's getting late also in Japan, and it's just about lunchtime, I think, in Europe, and it's probably a good time that we close the session now. But before we go, let me just thank Professor Watanabe and Professor Van Elst for bringing us such a wonderful conversation. It's a comparative conversation about Japan and about Europe, and this is most timely. And it's a very, very important topic, I think, which interests not only an academic audience, but also a professional audience in this part of the world, and certainly in many other parts of the world. Please, everyone in the audience, please join me in giving a virtual, I suppose, applause, a big round of applause to our speaker and to our discussant for such a wonderful session. Thank you so much.